For you who don't know me, my name is Mark Roche. I'm president of the Indigenous Lawsuits Association, and I have the pleasure of getting this day started. This event is very exciting. It's hosted by the Faculty of Education, the Faculty of Native Studies, the Faculty of Law, the Wahkohtowin Lodge and Governance, the First Nations Children's Action Research and Education Service, and of course, the Indigenous Lawsuits Association. We're delighted you can join us today. Please enjoy the late lunch. It was sponsored by the First Nations Child Action Research and Education Service, FN Cares, and the Wahkohtowin Lodge. And it was generously funded by the Alberta Law Foundation, and the beverages were supplied by Coca-Cola Activation Fund. Just a brief overview of today's events. Each panelist will present for 20 minutes, beginning with Dr. Hadley Friedland, and then followed by Dr. Cindy Blackstock. Panelists will respond to each other and discuss points that were brought up during their respective presentations, and that'll take about 15 minutes. And then Dr. Shalene Jobin, today's chair, will moderate a discussion between the panelists and then present some pre-written questions from the audience. So I have the pleasure of introducing Shalene. She's an associate professor at the Faculty of Native Studies and director of the Indigenous Governance and Partnership Program at the University of Alberta. Shalene is Cree from her mother and Métis from her father. She's a member of the Red Pheasant Cree Nation. Shalene is widely published and is involved in numerous community center research initiatives, including being the co-lead with Dr. Hadley Friedland in the Wahkohtowin Lodge and Governance Lodge, and the partnership between the Native faculty, the Faculty of Native Studies, and the Faculty of Law to provide governance supports to Indigenous communities such as those at AWN. So if you give a warm welcome to Dr. Shalene Jobin.
Welcome everyone. Thank you so much for being here today, and obviously this is an important day and an important topic, and we have amazing speakers to help lead us through it. So as a little bit of an FYI, each panelist will present for 20 minutes, beginning with Dr. Friedland and then Dr. Blackstock. Then panelists will have a chance to respond to each other and discuss points that were brought up during their respective presentations. And then myself as chair, I will moderate a discussion between the panelists and then present some pre-written questions from the audience. And so just as a note, the panelists can't answer direct questions, and so you can write down a question you have and put up your hand, and Evan, who's standing right here, she can take your questions. And also of note that individual situations could not be addressed at this time, but we do have a special guest with us today, Andrea Doyle from Legal Aid Alberta, and they have a table that's situated outside of the room to speak with you further about individual cases. Okay, Bill C-92, an act respecting First Nations, Inuit, Métis children, youth, and families, became law on June 21st, 2019. This is in part a response to the Truth and Reconciliation Commission's calls to action. For example, call to action number 4. We call upon the federal government to enact Aboriginal child welfare legislation that establishes national standards for Aboriginal child apprehension and custody cases and includes principles like point 1, affirm the right of Aboriginal governments to establish and maintain their own child welfare agencies. Importantly, the first 5 calls to action to redress the residential schools are about child welfare. This can be seen as a move towards Canada recognizing the inherent rights of Indigenous peoples. Also, this can be considered a move towards sectoral self-government. However, there are many unknowns and cautions. Today's talk is titled Bill C-92, the good, the bad, and the unknown. In a report by Metallic, Friedland, and Morales for the Yellowhead Institute, they note 5 areas where Bill C-92 falls short. Areas such as national standards, jurisdiction, funding, accountability, and data collection. Today, we are going to hear from experts that will explore the good, the bad, and the unknown. So again, if you have any questions, put up your hand and Evan will collect them. Without further delay, it is my pleasure to introduce Dr. Hadley Friedland. Hadley Friedland is an assistant professor at the University of Alberta, Faculty of Law. She is the co-lead of the Wahkohtowin Indigenous Law and Governance Lodge, a dedicated interdisciplinary unit that upholds Indigenous law and governance through community-led research and education. She was the first research director of the University of Victoria's Indigenous Law Research Unit and has worked extensively with Indigenous communities across Canada to identify and revitalize Indigenous laws. She teaches and researches in the areas of Indigenous legal traditions, family law, child welfare law, Aboriginal law, criminal justice, and therapeutic jurisprudence. She is the author of the book, The Wahkohtowin Legal Principles, Cree and Anishinaabe Responses to Violence and Victimization, released through the University of Toronto Press. Please, let's warmly welcome Dr. Friedland.
Well, thank you. I'm honored to be here. I'm honored to share space and have conversation with Dr. Cindy Blackstock here today and everybody that has come to think and talk about this really important subject. And I can see how much it means. So what I'm going to do is quickly give you an overview of Bill C-92, what it actually is, and what it means, so we have a sense of that before turning things over to Cindy here. So I can't see actually, so if I click it, has that moved?
Yeah.
Yes. Yeah? Okay, so, yeah? Disappear? I'm just going to keep talking and it's going to end up working. As Dr. Jobin pointed out, Bill C-92 is a much needed change. It's a response to the TRC calls to action and Indigenous advocacy and activism for decades. It's a response to the Caring Society case, and it's a response to a case called Brown in Canada, that addressed the harms that came from the 60s scoop. The reality is the human costs of the status quo are unconscionable. This is the first federal legislation in the area of Indigenous children. It's also the first official government recognition of a Section 35 Aboriginal right to Indigenous people's jurisdiction over child and family services. We're going to talk about concerns, but I don't want to underestimate what a huge step forward that is in the history of Canada. How are we doing with this? Okay, that's fine. But there's uncertainty. When you have a typical piece of legislation, you have regulations, policies, and practices guides. And we don't have anything like that yet. There's no court interpretations of this legislation, which also helps us when we have new legislation. This legislation has something called a concurrent jurisdiction model, which means the provincial law and the federal law can apply together as long as they're not inconsistent, and Indigenous laws can also apply. So that is going to create people needing to look at multiple statutes to apply the law. And there's no commitment or clarity regarding funding. What's happening with funding? Yeah. Okay, so there's two main purposes of Bill C-92. The first is that recognition of Indigenous jurisdiction over child and family services. For the first time in history, there's a recognition by the government that Indigenous people have the inherent right to jurisdiction, and that's authority over their own child and family services. This is going to matter. This law comes into force January 1, 2020. So in a couple of months, this law will be in force. And within a year, there will be Indigenous groups across Canada that are going to exercise their jurisdiction and legislate or write their own laws. The other purpose of this bill is establishing national standards. So this was in response to the TRC calls to action, saying this was imperative for the well-being of Indigenous children. The national standards come into effect this January. They will apply to all provinces. And where they are different from the Alberta legislation, this will prevail. This law will be higher than the provincial law. So I'm going to talk briefly about the national standards because we're 2 months away, and then I'm going to talk about jurisdiction more briefly and then turn it over. Let's say national standards. Yeah? Okay. So the national standards are coming into force. They're going to set out a number of standards related to child and family services. These are intended as minimum standards. It's raising the floor because there's inconsistencies across provinces with how Indigenous children are treated under child and family services statutes. Where, as I said, where provincial laws conflict, the national standards will apply. When Indigenous nations create laws under this legislation, it won't necessarily displace these national standards, but they may influence the interpretation of them. So briefly, this is a small piece of legislation. I'm sure nobody in this room loves to read legislation, even if you are in law, but it's not long. You could force your way through it, and I highly recommend it. The national standard sets out principles for interpreting and applying this act, including best interests of the child, and I'll highlight some unique factors in a minute, including cultural continuity, and in particular saying cultural continuity is essential for the well-being of Indigenous children, families, and communities, and that child and family service delivery must not contribute to assimilation or cultural destruction. They also set out the principle of substantive equality, that the child's family, and the child's Indigenous government must be able to exercise their rights under this act, including being heard. And that a jurisdictional dispute must not result in a gap in services. So when they talk about the best interests of the Indigenous child, they have something called a primary consideration clause. And they talk about the child, and people in the field will be familiar with this, they talk about the child's physical, emotional, and psychological safety, security, and well-being, as well as the importance for that child to have an ongoing relationship with their family and with the Indigenous group, community, or people to which they belong, and preserving the connections. So they bring those together, and they're often considered separately, so that's a move to stress how important those pieces are. There's 8 factors in the best interest of the Indigenous child, and I just want to highlight 2 here that are somewhat new compared to provincial statutes. One is asking consideration for the nature and strength of that child's relationships with any member of their family. And the other is the importance of a child's ongoing relationship with their Indigenous family, community, language, and territory. So to the best of my knowledge, adding in territory, this is the first time I've seen that, and people can correct me. And I think it goes to some of the work, including some of the work that Dr. Blackstock has written about, of connections and relationships going beyond even just human to human, right? The importance of that. I'm just going to this. This act sets out standards of how child and family services is to be provided, including taking into account a child's needs, the child's culture, their ability to know their family origins, and again, that promoting the substantive equality. They then have essentially 3 sets of provisions. They have prevention provisions, they have provisions around placement or apprehension, and they have provisions around protection or out-of-home or permanency care. So for prevention, they talk about the importance of prioritizing preventative care and prenatal care over other services, including in prenatal care if it's likely to be in the child's best interest and to avoid apprehensions at birth. And they also set out a socioeconomic conditions provision saying a child is not to be apprehended due to poverty. When we're looking at the situation of placement, there's a reasonable efforts provision, and this is similar to an active efforts provision in the Indian Child Welfare Act in the United States, saying that a worker or a lawyer is going to have to show reasonable efforts have been made to have the child continue residing with their family before an apprehension order will be granted. Then they have placement priorities, which is also something that is similar to ICWA, where they set out an order of priority with parents, with family members in the same community, in another Indigenous community, and then others. The importance of considering a placement with or near siblings and relatives, and the importance of taking into account customs or traditions about placement, like custom adoption. The standards that relate to protection set out notice and representation requirements. This is a significant change in Alberta. There must be notice given to the child's parents and care provider, as well as the Indigenous governing body, of any significant measure. So not just court, not just PGO, any significant measure. This is significant in Alberta because right now this is only given to bands in the Act. So this is a move that would cover Métis settlements, possibly cover the MNA, and cover non-status communities. And the same parties have the right to make representations if things do go to court. There's also an expansion of thinking about permanency, which is thinking about the permanency of cultural and familial ties. So there must be an ongoing reassessment of family unity. Where a child is in out-of-home care, there must be ongoing assessment to see if it is safe for them to return. And where a child is in out-of-home care, the attachment and emotional ties to members of their family are to be promoted. Again, we don't know what this is going to look like in practice, but it is a push toward the permanency of connections. So top 5 strategies, what should Indigenous groups be doing to respond to these opportunities and the challenges and gaps in this legislation? There's going to be a need for education. I was just talking to somebody from the Maritimes, I won't say where, who said they brought this up with a judge and they had never even heard of this. So you're going to have to assume people haven't heard of this legislation and are going to need to be educated. Just because people haven't heard of it doesn't mean that it's not law and it doesn't need to be applied. There's going to be advocacy for making sure this is interpreted in a way that makes sense. For representation and notice purposes, notice needs to be given to CFSA, so you can give that January 1 that you're representing children from your group. Working internally, particularly on definitions of best interests of the child and customs and traditions like custom adoption is an important piece of work that will help with the interpretation. And creating lists of resources within the community for children to stay connected. Okay. So the jurisdiction part. Okay, so this recognizes as a Section 35 right jurisdiction, and that's going to include authority to draft your own laws, not policy, not interpretive tools, but your own laws. to administer and enforce these laws, and to provide dispute resolution mechanisms. Your laws are going to have the power under this Act to have the force of law as federal law after a year, to prevail over all other federal laws, there's a few exceptions that I'll talk about, and to prevail over all provincial laws. So the example I give, which I don't think anyone will do, but if you say the law is a child from this community must have a new pair of sneakers within 24 hours of contact with a care provider, that if there's not a provision like that in the Provincial Act, your law will prevail. Okay. There's limits, of course, the giving with one hand, taking with the other hand. There are limits. Courts have said governments can regulate and justifiably infringe Section 35 rights. And the bill does regulate inherent jurisdiction. So your laws are going to be subject to the application of the Charter and the Canadian Human Rights Act. Where a child belongs to two Indigenous groups, there's a stronger ties provision where it would need to be determined which group the child has a stronger ties to, if that can't be worked out between the two groups. And then your laws will not be applied if they are deemed contrary to the best interests of the child. And this is, we'll talk about this later, but this is, best interest of the child is quite wide and broad, so that can create some protective factors, but some real concerns. For your Indigenous laws to be recognized as having the force of law, of federal law and prevailing over provincial laws, you need to give notice to the provincial and federal governments of your intent. You need to work towards entering into a coordination agreement with the provincial and federal governments, or have made reasonable efforts to do so within a year. If the government is not being reasonable back, your laws will still have the force of law within a year. You just haven't been able to negotiate a reasonable agreement, despite your reasonable efforts. And you need to be prepared for the minister to make public and publish your laws on a website. People need to be able to access them, and they need to be written down. So the limits, Dr. Blackstock will say, where's the money? What about the funding? The only clause that addresses funding is Section 22C, which states that governments may enter into coordination agreements. Now, those of you who are in law school will know that what we would like to see there is a must, because when you have a must, then that's binding and people need to respond. A may gives discretion. So they may enter into coordination agreements, which include fiscal arrangements, and that are sustainable, needs-based, and consistent with the principle of substantive equality. So again, top 5 strategies, jurisdiction, where do people even start? I think that internal work is crucial. Clarifying and developing, if nothing else, your own best interests of the child definition and factors. You know your children best. You know what your children need to be a healthy adult. So what do they need in their best interests? Giving notice, starting those conversations with the provincial and federal governments. Identifying your priorities, what's most important, what isn't working right now, what do you want to address? You don't need to address everything because it's a concurrent law model. And working together, there are Indigenous groups, communities, and nations working across the country right now on this work. And working together is going to allow for strategic sharing of resources and approaches. And finally, funding is not addressed. So this has been touted as a response to the Caring Society case, but it does not address funding. So advocating and supporting advocacy for substantive equality remains crucial. So I'll leave it at that, and I'll turn it over now. Thank you.
Thank you, Dr. Friedland. Just a few reminders that you can put your hand up, and Evan and Melissa from FN Cares, if you put your hand up and you have a question, they will take them and provide it for a Q&A period at the end. It is now my pleasure to introduce Dr. Cindy Blackstock, a member of the Gitxsan First Nation. Cindy is honored to serve as the Executive Director of the First Nations Child and Family Caring Society and a professor at McGill's University School of Social Work. She has over 30 years of experience working in child welfare and Indigenous children's rights and has published more than 75 articles on topics related to reconciliation, Indigenous theory, First Nations child welfare, and human rights. Cindy was honored to work with First Nations colleagues on a successful human rights challenge to Canada's inequitable provision of children and family services and failure to implement Jordan's Principle. This hard-fought litigation has resulted in hundreds of thousands of services being provided to First Nations children, youth, and families. She recently served on the Pan American Health Commission on health equity and inequity, and fundamentally believes that culturally based equity is fundamental to meaningful reconciliation. Cindy is frequently cited in the company of the Caring Society's Reconciliation and Bear Lister, Spirit Bear, engaging children in meaningful actions to implement the TRC calls to action. Please warmly welcome Dr. Blackstock.
Want to recognize the Treaty 6 territory that we're on, and that it's Métis Week here in Alberta. And I'm wearing my Spirit Bear t-shirt, and although my colleague did not show you, we are both wearing Spirit Bear's t-shirt, and there's a reason why. Spirit Bear is up on your screen. He's that teddy bear. He belongs to all First Nations children and all non-Indigenous children who have stood together during the now just about 13-year-long case before the Canadian Human Rights Tribunal to try and get culturally based equity for First Nations children in this country. And he is an important symbol, but also a reminder that we still have to fight for that in 2019. What a lot of people don't know is that public services are funded by the federal government on reserve, whereas they're funded by the provinces and territories for everybody else. And going back at least 112 years, the federal government has known that they unequally fund those services and have linked those inequalities with the deaths of children. They have failed to respond to numerous reports throughout the decades saying that they should fix this. And now, at the Canadian Human Rights Tribunal, we are on our 10th order against the Canadian government since 2016. Now, I want you to remember that this is all about just treating little kids fairly. And it's within that context that we get this new bill C-92 coming up. And you have to wonder why it's emerging at the same time when a government is fighting so hard to obfuscate its fulfilling of legal orders to treat children equally. And that's what I want to talk about a little bit. First of all, to say why equality is so important. If I was Prime Minister today, and I do think it's time for a female Prime Minister, I really do, right? Because I have no skills in politics, but there's somebody out there. And if I was Prime Minister, I'd actually want to reduce things like criminal undertakings in community, reduce child welfare, reduce the number of mental health issues. I'd want to bolster the economy. I'd want to get rid of things like, reduce as much as possible diabetes and cardiac care. I'd want to increase housing opportunities for folks. And I actually can do all those things just by reducing the inequalities in our own country. That's the magic silver bullet. If you don't reduce those inequalities, then you see all of those different social ills. And that's why the cross-cutting inequalities for First Nations consistently put First Nations kids at the top of every list you don't want to be at the top of, and the bottom of every list that you do want to be at the top of, right? So this is not an accident. And the Tribunal, Canadian Human Rights Tribunal, has found this as a matter of fact. They said that Canada is willfully and recklessly discriminating against children in ways that contribute to their deaths and needless family separations. This is not a matter of opinion, it is a matter of law, a legal finding. This is a report that we just finished at the Pan American Health Organization, headed by Sir Michael Marmot, one of the world's experts on health equity. Now, many of you are familiar with the determinants of health, and it's not a bad model, but the problem is with the determinants of health is it leaves out some very important factors for Indigenous peoples. So this actual model includes, for the first time, the land as a determinant of health. Not just climate change as a determinant of health. That's been getting a lot of pickup in the non-Indigenous media, well deserved. But for Indigenous peoples, the land is more than that. The land is part of identity. The land is part of relationship with ancestors. The land is the source of culture. It is the source of medicine. It is the source of so many things, spiritual teachings. And so this recognizes that sacred relationship. The other thing it does is recognize self-determination as a determinant of health. And the fact that colonialism is fundamentally about other people dreaming for our kids and claiming their dreams are superior to our own. And that has been going on for years. As Marie Batiste, the great education activist, said, is in the beginning, we dream for our own kids, and then the government of Canada started dreaming for them and has issued a number of apologies. And now what the government wants to do is tell us how we're supposed to raise our kids. And I worry a bit that that's where C-92 is going, right? Instead of what we want, which is that freedom to dream for ourselves. So this is a report, you can check it out online. These are the multiple opportunities Canada's had to fix the inequality in First Nations child welfare. And I raise this because a lot of people assume these inequalities exist because Canada doesn't know better. We hear from politicians all the time, we're making good first steps. We did more than the previous government did. Right? Does this sound familiar? And we just want to talk with partners. I don't understand what that means. And I don't understand what engaging with partners means either. Because under the UN Declaration on the Rights of Indigenous Peoples and through several Supreme Court decisions, they are not ordered to talk with partners. They are not ordered to engage. They are required to consult. And Canada does not use that word with respect to First Nations children because it engages specific legal responsibilities. It wants to operate outside the law, boundaries of the law far too often. In this particular act, I wonder too what an Indigenous group is, governing body is. I don't know what that means. They seem to have invented a whole pile of new words, at least new to me. I think new to many other people too. And the problem with that is it introduces confusion into a system where children are at the center of it and their vulnerable families. And they don't need that lack of clarity in an act. And it was not necessary. There actually was a First Nations draft of the act. Does anyone know that? Led by Mary T.G. out of Carrier Secondary Family Services. You can go on to fnwitness.ca and you can see a draft of a First Nations Act. We wrote our own act and handed it to Canada and said, use this. But instead, they drafted this thing with all of these uncertainties. And in my view, and Hadley would might have her own view, but I think the First Nations law is far superior to this one, right? But it's still there on our website and can be used by leadership to inform what might be our laws. Okay? So, we'll see. I'm going to struggle with the same thing Hadley was doing. I thought I had it whipped by standing up here. This is the decision by the Tribunal from 2013. It is the first time in the Western world where a government has been put on trial for its contemporary treatment of First Nations children. It was filed by the Assembly of First Nations and our organization, the Caring Society, back in 2007. Canada fought it tooth and nail for 9 years, bringing many jurisdictional motions to try and get it dismissed, but ultimately they were unsuccessful. This is the panel's finding, where they order Canada to cease its discriminatory conduct. 2 ministers come out, Minister Bennett and Minister Rabel-Wilson, and they welcome the ruling. But then Canada didn't implement it. That's why we've had 7 non-compliance orders issued by the Tribunal, 10 orders in total so far, and we're still adjudicating things. I want you to take note of that, because when we get to these coordination agreements that Hadley is talking about, you've got a year to discuss funding with the federal government. I have been discussing funding with the federal government just personally, and there are many people before me that were at this, but I started in 1997, that was 22 years ago, and we have the benefit of 10 legal orders, and we're still discussing with Canada. So how much progress can you make in a year, right? Which raises for me one of my key recommendations. If you are going to go down this road, in addition to the many pieces of good advice Hadley gave you, please negotiate your funding agreement first. Do not trigger that coordination agreement until after you have the funding sorted out. Because Canada said in testimony, when many people, I think you were saying every witness came forward about money. Every witness said they wanted a positive obligation on behalf of Canada to fund these laws. And Canada's response is, we'll deal with the money later. It's not jurisdiction. I disagree with that. I think it's fundamental to jurisdiction. No child welfare agency in the world operates without public money. They don't. And you can, it doesn't matter if you have your own law and you have no resources to meet your members' needs, right? It really is another false promise. So here's the orders that we're waiting for at the Canadian Human Rights Tribunal, and these are vital for leaders to know about. Capital. Canada has been ordered to provide prevention money for the first time to First Nations agencies. That's starting to flow. But no money to build buildings to house those prevention programs. So we're litigating against that. We're still litigating on Jordan's Principle to try and get it extended to children who are recognized by their nations as members but don't have Indian Act status. So that's still coming. And we have small agencies. And we're also dealing with long-term reform of Canada's funding mechanisms. And in that regard, this is a critical study that most people don't know about. Does anyone remember Kevin Page, the Parliamentary Budget Officer? He was appointed by the Conservatives, and then they weren't too happy with him because he kept on pointing out all the flaws in their economic plan. And the Liberals replaced him. That was their answer to it. He was too good at his job. But he set up this institute. And he's been working with what we call the National Advisory Committee on Child Welfare to cost out not just the cost of child welfare. And that's another problem I see with this act. It actually is a child welfare law. When we have at the Caring Society work with nations around their definitions of what a healthy family and child is, they don't have child welfare laws traditionally. There are family laws. So already the thing is shaping what that vision looks like. That's contrary to often what the community's legal systems would have been. And at any rate, with this narrow conception is really putting us also in another pigeonhole around funding. And what we asked, the National Advisory Committee asked Kevin Page and company to do is cost out what it would cost for First Nations kids to thrive. What if we lifted all the kids out of poverty? What if we gave them good houses that don't make them sick? What if we all had clean water to drink? What if we had enough addictions programs and trauma programs to respond to multi-generational trauma? That's the model that's being costed out right now. That work is underway. Unfortunately, they're being held back because guess who is not providing a lot of their data? So the federal government has been very slow to deliver on that data. We're hoping that we've reached a turning point in that. But it makes you wonder, too, why they're not providing the data, right? But anyway, this should be out in the summer. And I think it will be critical for First Nations who have a vision of child wellness that goes beyond child protection to really take account of this important work. Where am I with time? I'm good? Okay. So you can go onto the website and they have multiple updates. One of the key pieces about this is we wanted to make sure it was really transparent. So nation members, students, whatever, can go up and see what we're doing next on this whole research project. And there's even some occasional helpful videos. And it's all governed by the OCAP principles and the Tri-Council principles on First Nations research. And I'm just going to let you all know at this time, because I won't be able to properly say it on time, I'm sure, is that there's some law students who have to go to another course, although I'm sure they want to be here instead. But they'll be leaving us in another 5 minutes, and I just want to thank you all for coming, all right? And staying as long as you could. All right. Compensation, right? This has been in the news. Who here watched the English or French debates with the leadership? Yeah. You heard about this case. So under the Canadian Human Rights Act, the tribunal has the authority to grant up to $20,000 per victim of discrimination, and a further up to $20,000 if such discrimination is willful and reckless. The tribunal put this decision under reserve in 2013 because they wanted to focus on ending the discrimination, getting rid of the most egregious elements of Canada's ongoing discrimination first, and that was the right decision to make. But then they got back to this in the spring. In the spring, we had a mini trial, if you like, on compensation. And the reason we had that trial is that Canada refused to mediate compensation for the year before that. We were all willing to mediate compensation. Canada refused and sent us an official letter saying the only way it's going to be resolved is through litigation. That was in November 2018. So we went to this mini hearing. This is well before the election, I just want to point out. Well before the election. No writ had been dropped. There is no caretaker provision. The government's position was it owed nothing to the children who were brought into care. It owed nothing to the families wrongfully affected by Jordan's principle. The grounds upon which it said it owed nothing, it said that this was a systemic case of discrimination. And had we wanted individuals to receive compensation, we should have had the victims testify themselves. Now, can you imagine this? We're talking about children. And Canada is suggesting we ought to have had them testify about what it is like for them to be removed from their families or to be denied services. Now, granted, not all the victims are children. Some are adults, but the vast majority of them are children. We rejected that wholeheartedly, and we pointed out that the Canadian Human Rights Tribunal had indeed provided damages to individual victims of systemic cases through pay equity cases. So this was not something new and novel that the tribunal was doing. So the tribunal took the decision on reserve. It's released on September 4th. It grants the maximum amount of $40,000 per victim of discrimination. It says that Canada is, and I use that in the current tense because I mean it currently, it's ongoing, is willfully and recklessly discriminating against First Nations children. Canada calls the election. Then we get the debates coming forward. We want to talk to partners, they say. Meanwhile, they're not talking to us, right? They were ordered by the tribunal in that September order to do one thing, and that was to talk to the Assembly of First Nations and Caring Society about a process for the distribution of the money. Then when those submissions went in on process, which was December 10th, the tribunal would issue another order on payment. But Canada was not talking to us. But it turned out in evidence that they were talking to other people. And they said that they didn't want to talk to organizations. They wanted to talk to the victims of the discrimination. Now this is interesting, right? I want you to think this through. Canada, in its legal submissions, where they wanted to quash the order for all financial compensation, so they're seeking to quash any financial compensation. They are still recklessly, willfully and recklessly discriminating against kids, and they want to talk to them, right? The hubris involved in that is very concerning to me, because it suggests that they have not understood fully what they are doing, right? So the Prime Minister said that he will pay compensation. There is a class action that is also being filed, but that's separate from human rights damages. There's nothing under the Canadian Human Rights Act that says that a person who receives compensation as human rights damages cannot also file a civil suit or receive damages in another mechanism, right? So we are going to court on November 25th and 26th to try and address Canada's application for a stay. What they want is they want to put the Tribunal's order on hold, so there's nothing happening on December 10th. And then they want to set down the dates for their judicial review to quash all financial compensation. So Aboriginal People's Television Network has applied to televise that. The Caring Society's already consented. We're hoping the other parties will as well. And then you'll be able to watch it on TV. And we really want you to be able to watch it because it's about all of your kids and community members, and you have a right to see what's happening in that courtroom. But this is another indication about the environment we're walking into, which to me is a worry about C-92, is that Canada's refusal to put anything in there that bound it. So although it sounds nice to say we're not going to remove for poverty, without funding for housing, water, sanitation, how are you going to implement that? Prenatal care. Prenatal care, sadly, is not available in many First Nations communities. There was wording proposed to it to make it a positive obligation. Canada took that out. So now you have a right to prenatal care, but no money to provide that prenatal care, right? So I just want to provide these cautions so that people don't assume that you're just going to be able to get the funding for your particular program. So I'm just watching my clock. Okay, so here's the deal on the money. Now, the other thing about the compensation is Canada actually wants us to pay for their legal fees. So that's what they're asking for. Anyone who opposes them, they said. And so Spirit Bear now has a piggy bank, as you can see. We're trying to raise funds. And I want to just really give a shout out to our lawyers and law students who are helping us right now. Canada spent over $10 million just on legal fees on this case up until 2016. I have an access to information request in now to find out how much they've racked up since then. But our lawyers have worked completely pro bono for the kids. And so, like, I mean, this is a huge case that takes up a lot of time. So I'm going to say their names out loud because they don't get the thanks I think that they deserve. And that's Sarah Clark, David Taylor, Barbara McIsaac, and Anne Levesque. So they've done an outstanding job. We have, thankfully, through the Tribunal's order, and I really want to emphasize this, the collective efforts of leadership and agencies and many caring Canadians. We've been successful at the Tribunal at eradicating some of the most egregious inequalities in First Nations child welfare funding. And some of that money is now going to agencies, and that's a good thing. They're starting to be able to do some really good stuff that they've always dreamed of. But here's the hitch. If you assume that that agency operating under First Nations law, that the money the agency currently gets will transfer over, that's a false assumption. Canada has something called terms and conditions, and it has restricted the monies payable to agencies to only those operating under provincial and territorial law. They renewed those terms and conditions last year. We, the Caring Society, along with the Assembly of First Nations, said, you understand you're working on the C-92, we'd like you to expand that definition to recognize First Nations laws. Canada refused. So they say it's theoretically possible that you could get some of the agency money, but it's by no means guaranteed. They say you have to go through this coordination agreement. Another thing, agency funding is insufficient. And if we had a First Nation, for example, who pulled out of the agency as of January 1st, they are also, if they're part of a tribal council, they need to understand they're part of a collective where that money is creating an economy of scale, right? If you pull out only your portion of that money, you're not going to have enough money to run something, right? You're going to end up with very little, which means this negotiation of the funding first is going to be critical, because you're going to need more money than what the agency has. And not only that, you're going to probably have more greater visions for your kids than what agencies can currently provide. The other thing here is that, no, I think I've covered all the rest of that. Yeah, we had tried to put in language in the act that would oblige Canada to follow the CHRT funding principles. Substantive equality, Jordan's principle, respect for differences in distinct communities, like your location, your needs of that community, and best interests of the child. They did not include any of those as funding principles. They said they could not because it applies to Métis or Inuit. We then asked if they would provide a First Nations version of that law. They refused to do that too. So the question then becomes why, right? And I remember a 2012 PowerPoint where they actually talk about how they're going to get themselves out of the mess of the Tribunal. And one of them was to transfer authority. So we have to guard against that, is what I'm saying. I'm a real believer in First Nations jurisdiction, Métis and Inuit jurisdiction. I just want to be clear that what we're getting offered here is not another broken tree, right? Especially because it comes to kids. Now this is a solution. Whoops, back. How do we get this thing to go back? There he is, spirit bear. Oh, okay, without the big thing. Oh, this thing is not exactly cooperating. Where is the spirit bear plan? We're going to try and bring up Spirit Bear.
Yeah.
We have a plan to eradicate all these things. Spirit Bear does. All the inequalities, which we think is the baseline to success for First Nations laws. We want two things. We want to have an independent evaluation of the Department of Indigenous Affairs. It is a repeat offender when it comes to First Nations kids. Residential schools, the 60 scoop, and now this willful and reckless. So we need to understand why it fails to do better when it knows better. And it cannot do that itself. It's not that there's mean people working in the department. It's that the architecture of the place creates an environment where people are collectively perpetrating these injustices. So it needs to be an independent evaluation. There's never been an independent evaluation of the department. Then we need to link things like compliance with the CHRT, compliance with the United Nations Declaration on Rights of Indigenous Peoples, compliance, as Hadley said, to the Truth and Reconciliation Commission, calls to action, the MMIWG calls to justice, with the pay bonuses of deputy ministers, because they do get pay bonuses. But right now, the pay bonuses go in a different direction. The second part is a very simple part of the plan. Ask the parliamentary budget officer to cost out all those areas of inequality in housing, water, addiction services, youth recreation, culture, and then work with First Nations leadership to create something like a Marshall Plan to address all those areas of inequality. We have to stop normalizing racial discrimination as fiscal policy. And what Canada has done for 153 years is they've done it program by program and drop by drop. And then they expect us to be thankful, right? Every time there's a budget, I get the question, oh, well, they put more money into water. Aren't you thankful? And you feel like you should be thankful because you're worried if you're not thankful, they're going to take away the little of relief that your kids have. But the problem with being thankful is that we then feed into the perpetuation of racial discrimination against our kids. We should never be grateful for any child getting even a penny less because of their race in this country. That does not deserve gratitude. It does not deserve any kind of excuse around first steps or we're trying really hard. If they can create equality for the millions of non-Indigenous kids in this country, they can darn well do it for First Nations kids. Racial discrimination should not be used as my time is up. I'm going to leave it here. And I hope I'm not leaving you on too much of a down note. But I do really think that I really believe in telling, sharing what I know to be the truth for people, so that you can make the best decisions for your communities. I should also say that Canada has no transition plan for this act. So, and there are no regulations for this act. There's no court rules for this act. So all of these areas that are unclear when you read through it, well, there's not going to be any more clarity by January 1st. And so, yeah, that's what I want to say. And then I think, Hadley, we should move this out of the way, and then we can just sit here and talk, right? You know? And everybody can see our Spirit Bear t-shirts, which were made by Corn Lightning Earl. Does everybody know her?
Oh, yeah.
Yeah, and like we now think she can make a business out of these t-shirts. Because everybody wants a Spirit Bear t-shirt, but in order to get one, you have to be supporters of the Spirit Bear plan, right?
That makes sense.
Yeah, exactly. You know, Spirit Bear is not your homie, or he will not be your homie unless you support the Spirit Bear. I can speak to Spirit Bear on that one. That's pretty good. Okay, good. Now we get rid of this nasty device that doesn't work. There you go. Maybe it's made in Canada.
There could have been funding issues.
There could have been funding issues with the dancer there. Oh my God, people did have questions. But the problem is we probably won't be able to answer them. Okay. So let's go.
So now we have time for questions, and again, Evan is walking around, so if you have a question, please raise your hand, and Evan will take the question from you. So she's just right there. So we'll start with the first question. With new legislation, how will it affect the urban Indigenous children and families?
No one has really given that a lot of thought. I wish I had a better answer for you. In fact, some of the urban First Nations, Métis and Inuit organizations who are providing child welfare had actually asked to testify in front of the Senate and Parliament and were refused by the government. So the National Advisory Committee on Child Welfare has been there, and the Native Child and Family Services of Toronto have begun to have those conversations. First Nations leadership in different communities have had those conversations, but it's very much in the beginning stage, at least on a national level. And I don't think that was thought out well at all in terms of the government side about how to meet the needs of First Nations, Métis and Inuit peoples in urban areas. And I think that's something to look for as C-92 gets rolled out. As Hadley will say in a minute, all the standards now apply to you too. So that's a positive if your legislation falls below the standard. And you said if they're in conflict, the federal law prevails, but what if the provincial law is better?
Yeah, that's interesting. So I mean, this is some of the uncertainty. One of the things I wanted to say, just focusing on those national standards, and I'm a little biased, but I see Chimo and Bentero in the room. And I think some of those national standards, people that are in the field already practicing best practices for what we know Indigenous children and families need within urban settings, are going to look at these standards and say, we're doing this or exceeding this, you know, kinship care provision. I think of the coming in the doorway of Bent Arrow, and there's all those arrows pointing to all these different First Nations in Alberta, that orientation, right, of where children and families are coming from and remain connected to. So in a lot of ways, people have a sphere of power to work right now in being forerunners with this legislation. That's sort of like, I was like, you say you're Debbie Downer, I'm Pollyanna.
That's good, we balance each other out, right?
Yeah.
So would a provincial law that had stronger placement principles, would it prevail over this?
So what I would think, I mean, first of all, I would welcome anyone to show me a provincial statute that has stronger placement principles. I don't think so. But when I look
C
at,
has some pretty good ones.
do they have stronger? I would have to look. If it's congruent, it doesn't come into conflict. So that's the, if this law says go to 7 and a provincial statute goes to 10, there's no conflict there, so I would say that would be fine. I think it's more the provinces where the provincial law says we'll only go to 5, and it says we'll go to 8, that it will. But it's uncertain. It's true.
What responsibilities do provincial governments have? What 3 things should the government of Alberta do?
Adopt Jordan's principle. It is not done. And I know the leadership here in Alberta trust them on that. And that would be important for persons on and off reserve, because that would eliminate the gaps in services there. I'd also like to see something like Jordan's principle extended into adulthood. I can't believe that something is discriminatory for someone who's 17 years, 364 days, is not discriminatory 2 days later. And we need to tackle it. The other thing is Alberta needs to become a better ally in addressing the willful and reckless discrimination, not only with the federal government, but also within its own borders. And I'm very disturbed to see, for example, the planned reductions in the level of support provided to youth and care. That is an outrage. It's against provinces need to be doing is working with First Nations, Métis and Inuit leaders in their jurisdiction around C-92. And they need to pony up on the funding too, right? So this case is against the federal government, but I think something similar could be brought against the provincial governments. And we need to keep in mind, or at least, I'll check with Hadley, but when we filed this human rights case, it was actually easier to file it against the provinces. Because the provinces have in their Child Welfare Act that the children are supposed to, safety and well-being are supposed to be their paramount consideration. And that's consistent across every provincial territorial statute. What we found out is that in practice, the provinces would only do that if they got a check from the federal government, right? And so it was easier to litigate against the provinces to bring them up to the same funding principles that we've now got the feds up to. And I'd like to see the province of Alberta voluntarily adopt the CHRT funding principles across the board.
What I would add with that is this act recognizes Indigenous jurisdiction as an Aboriginal right. That doesn't mean this act isn't delegating that. It's not making it happen at this point in time. It's recognizing that jurisdiction has existed for thousands of years pre-Canada, through all these years where it wasn't being honored and recognized. So I think that tone of conversations, that starting point of recognition of jurisdiction is crucial to all these conversations.
And another reason it's crucial is that this only recognizes inherent right in child welfare. But when I was doing child welfare, I did it for 13 years, we actually operated under 23 different pieces of legislation. And all of those other 23 pieces, as it stands right now, are under provincial jurisdiction. So there will need to be, the provinces will need to be open-minded and supportive of this idea of jurisdiction and aligning those other pieces to a self-determining vision.
Thank you. Okay, I'm going to put 2 questions in one. What do you think of the bill's definition of best interests of the child? Whose term is this? And then best interest legal test has been law formally. The Indigenous factor has long taken a backseat to other factors. How is this going to change with Bill 92?
I'm going to let the expert take this one. She's written a lot about this.
That is true. I mean, that's a huge concern with this bill. I think there's a funding, and I think there's a best interest of the child. We hear best interest of the child intuitively. We think this is wonderful. We want the child needs at the centers, right? But that's not how best interest of the child has been interpreted by courts. So there's a case called Worsen and Woods, and what's ended up happening for countless Indigenous children and families over the years best interests of the child has been interpreted as saying Indigenous children stay in non-Indigenous homes, as opposed to returning to family or communities, or even maintaining those connections that this Act talks about. So that's a huge concern. It's an area of discretion. It's open up. There are some extra principles. There is that primary consideration principle that pushes, suggesting another interpretation. But is it strong enough to overturn a Supreme Court of Canada case like that? And the years and understandings, it's an open question, and it's going to require, I think, like everything in this Act, advocacy. Sometimes people refer to Cindy as a tireless advocate, and we were talking in Ottawa. Actually, advocacy is tiring. 13 years for something that seems so simple and straightforward, right? And I think best interests of the child and funding both tell us that this advocacy is not stopping with this act.
And one of the things I'd say on practice on best interest, and does Alberta still use a structured decision-making tool in child removals? Risk assessments are called. See, the problem with risk assessments is that they do, what they do is they codify structural discrimination as a parental deficit. And then they interpret best interests within that. And that's something that we have to try and tease apart. I did child protection on the front lines in the downtown east side of Vancouver, on the north shore of Vancouver, and then also in the Squamish Nation. And I'm all about helping people speak to the fire for things they can change, right? Parents and caregivers who are making inappropriate choices need to have their feet held to the fire to make choices that are better for their kids, bottom line. But that assumes a couple things. One is that they have the resources available to learn how to do differently, right? And second of all, that they are making that choice. The word choice assumes the ability to choose. But when I do child protection, even in Main Street, I wouldn't even look at the addresses on the houses. I just look at the poorest house on the block, and 90% of the time, that was the one I was going to. So if we are not addressing those drivers of putting the family at risk, we will never get to the safety of the child and the best interests of the child. We need to look at that equality stuff in that policy report.
With the new fiscal arrangement, it refers to Indigenous governments. The terms and conditions are very limited. Have you reviewed the impacts to the C-92 legislation?
Well, I can't say anything more than what we have. We've tried to get information from the government. They haven't been particularly forthcoming. I will say, I want to draw your attention to something that's important and a lot of people don't know, is the federal government is already using C-92 in its own legal cases. It is using it to legitimize its desire not to pay compensation for First Nations kids. So if you look at Canada's legal submissions, it said that the Tribunal erred in its decision of awarding compensation because it didn't take account of C-92. So it's already using it to shield itself. So those of you, like Hadley, who've got far greater legal minds than I do, need to look at that. Why they're using it in that fashion, to be able to shield themselves from their own duties and obligations. That's problematic. But in terms of funding, stay tuned. And watch carefully what they do with the tribunal. I suspect if a capital decision comes against them, it would not surprise me at all to see another judicial review. Right? And the reason they will judicially review that is because it's going to cost them a lot of money. Because discrimination against First Nations people has saved them a lot of money. And they don't want to have to pay up this amount, right? But we cannot allow fiscal racial discrimination against children, period. If it costs us a lot of money, I say pay it. Because for every dollar we expend on eliminating this discrimination against children, the Canadian government will be $18 richer for every dollar it spends downstream. The reverse is also true. If they continue to have this fool's gold savings on the backs of kids, they will pay $18 US downstream. There's no way of getting around it. Not to mention, just it's immoral to racially discriminate against kids.
Do you know any support or assistance two Indigenous governing bodies to negotiate coordination agreements.
Wow. There's a pool of money federally called the CWJI, and I can't remember what it is. Child Welfare Jurisdiction Initiative. And the feds have said, okay, it's $80 million, and First Nations, Métis, and Inuit can apply to get this money. But here's the hitch. Remember the special representative on children and youth, Cynthia Wesley Esquimalt? The feds hired her to go out and do a report. And while she did that, she actually set up some funding deals with different communities, multi-year funding deals. But then Canada had to find a way to pay for that. So they created the CWJI and rolled all those agreements over. Because they're multi-year agreements, and the process was not transparent, it wasn't out to all First Nations to apply to this. It really was based on, you know, more if you were there at the moment. I have received confirmation from the federal government, and this is the only monies you can have to operate prevention outside of the delegated provincial model, or to develop your own laws, that there is no money in that fund for this year. It's been fully allocated, and there's no money in it for next year. It's been fully allocated.
How do we hold CFS accountable when my child's rights aren't being respected?
Well, number one, I think is really important. You've got the Child Advocates Office here in Alberta, and you've got one of the more effective child advocates in the country, Del Graff. So like 3 cheers to him, right? And so you can go to that office and do that. The other thing is that you have a provincial human rights commission. So if you feel that the unequal treatment of your child's rights is related to one of the prohibited grounds, and by that I mean, and Hadley will help me with the list here, but gender, race, national ethnic origin, well, disability, what else am I missing? Is there anything?
Now you're putting me on the spot.
All right. Well, basically those categories. Yeah, etc. You can go to the Alberta Human Rights Commission and launch a complaint like that. And talk to the folks at Legal Services who have got that table outside. Really, and what else I would say about it is we have bookmarks outside, 7 free ways for you to make a difference that will uplift all First Nations children's rights. Takes 2 minutes, completely free. So don't just focus on your kid. When we lift up all kids, we lift up everybody. Same thing? Okay.
Placement priorities and cultural, linguistic, religious, spiritual upbringing has always been part of all CFS legislation. How will this change with this new bill?
I mean, this is the crux of this bill. Does it change anything? I do think these provisions are stronger. If you love looking at legislation, if you look at legislation, the Alberta legislation and this legislation side by side, it is stronger. It's more precise, and if it's going to change anything, it's going to require advocacy and push and funding, right? The biggest risk of Bill C-92 is it may change nothing. It may be that people can look at this and try to interpret it down, so they maintain the status quo. And it's going to require pushing and saying that this is saying something more, something firm.
What about a situation where a child or youth might disagree with the law or the new plan? What about their voice?
Yeah, this is another gap in C-92. Another big gap, by the way, is post-majority care. It says nothing on post-majority care, despite the courageous and very eloquent presentations made by Youth and Care to include it in the Act. Canada chose not to include it in the Act. And if it had been in the Act, it would have been a good thing here in Alberta, because we could have then pushed it to 24 and said the federal act was superior. So we're already seeing where the good recommendations from Youth and Care would have made a huge difference already as of January 1st if they were only listened to. I don't know of any provisions where there are respecting the rights of children and young people to participate in the or in any major way other than to participate in the proceedings. But that's not even clear about what supports they'd be given to do that. And so I'm going to turn over to Hadley.
I mean, I can't give a much more hopeful answer. There's two provisions that do speak to, under best interest of the child and under substantive equality, that speak to the importance of recognizing children's rights, including children's rights to have their views taken under consideration. What happens in this act, like all child welfare and family law, is that's at the discretion of the decision maker. So the voice gets heard, but there's nothing that amplifies that voice or sets out a way, a structured way for people to balance the provisions.
And a way you can help is actually get out there, and if you have money to donate to your local youth and care network. They often operate under a shoestring budget, but their voice is so essential. And I will say that for the compensation piece, the Caring Society used some of our donation money, and AFN kicked in too, so that we could bring 18 youth in care, First Nations youth in care, to advise us on this process, and we're really grateful to them, and we found their advice extremely useful. So we plan on continuing that process, and we need to support groups like that so that we get that voice from the ground.
Does this legislation allow for repatriation for children of missing and murdered Indigenous women and girls?
That's going to be a really complicated case-by-case issue, and one of the heartaches of this bill, we heard that youth in care are saying, what about us? What about post-majority care? And similarly, we're hearing that from people saying, but an adoption's already gone through, a private guardianship has already gone through. What about us on the other side? And the families are saying, what about those children? What about repatriation? So again, we don't have great tools in this act. We have those emotional ties and we have that revisiting. And so that's going to require real advocacy and pushing. The one place I'm aware of is the Anishinaabe Nation in Ontario. They've come out very strongly. They have an extensive law that's quite comprehensive, and they've said repatriation is part of our law. We are going to pursue it. And they're doing that through relationship building with parents, with foster parents, and with agencies that are in urban settings or ways. So they're the forerunners, I think, of there that are really acting on that.
Yeah, and you can see their law. They're very generous about sharing it. It's on a website called the Anishinaabe Child Wellbeing Law. So, and they just appointed their own, the Wiki First Nation in Ontario just appointed their first children's commissioner. So there's pockets of real hope and success and examples happening all over the country, including here in Alberta. What we need to do is make sure that this law provides a platform to amplify those successes and to support others who are just beginning that particular work, and isn't used as a sword to further disable the rights and abilities of communities to care for their kids.
So I noticed that the time is running short, so I just want to give two of our speakers a few minutes to share any last thoughts or things that we should think about or do moving forward.
Maybe I'll just add to say that advocacy point. The status quo isn't acceptable. This act gives tools, but it's not the silver bullet. So we're going to need advocacy, we're going to need courage, and we're going to need work from people working in the front line in urban settings, to First Nations, and lawyers and judges to take courageous steps and use what can be done with this act.
And I just want to thank the Indigenous Bar Association, because they had Hadley and I on his panel, and that's where we got these free t-shirts. But they also, we had a good discussion there. And there's nothing preventing, who can say this, nothing preventing First Nations, for example, in passing a law on, say, January 1st that says a post-majority is part of our law, therefore takes supremacy over the Alberta law. Or that we do embrace the CHRT principles in funding, and Canada does have a public and positive obligation to fund, and so does Alberta. So anyway, I'm just going to leave it there. There's people who are far smarter than this stuff than me, including a lot of leaders who probably are already thinking about this stuff. But I just think, you know, where sometimes we got to take straw and weave it into gold. And when kids are at stake, I want class.
I want to acknowledge the Indigenous leadership that's in the room today, and thank you for all of you for attending. I want to remind you that Legal Aid Alberta resources and Student Legal Services education resources are outside of the front door.
And they have brochures.
They have brochures and booklets that are available as well. Andrea and Doug from the Legal Aid Alberta are there. Also, we have this video that will become available of today's show and important education, and that will be available. If you are interested, you can email fncares@ualberta.ca. And it's just been such an honor to be a part of this event today and to hear from these experts and just to have our hearts in the right place for Indigenous children. Thank you.